Hi, Tony DeWitt here. I'm a Missouri appellate attorney and a guy who answers questions here on YouTube. And today we're going to talk about judges, so stay tuned. Generally speaking, there are two kinds of judges in any state: state court judges and federal judges. Now, those are both broad categories, and there are subcategories within each, but generally a state court judge is appointed by a state appointing authority, whether that's by the governor or some commission. And in some cases, and in some states, the judges are elected directly by the people, and they gain their judicial power from the people themselves. Now, federal judges are completely different than that. Federal judges are they are recommended to the president by the state senator from the state where the district court sits. And that state senator says, I want you to appoint, Joe Blow. And then the president nominates him to that judgeship. After the president's nomination, he is investigated by the FBI, and if found suitable, then the Senate meets and confers and either confirms his appointment to the bench or denies it. But a federal court appointment, whether it's to the district court, the Circuit Court of Appeals, or the Supreme Court, is an appointment for life. The Constitution says that judges shall enjoy life tenure so long as they exhibit good behavior. And we've all come to understand that that means that a federal judge doesn't get removed unless he is impeached by Congress, which happens very, very rarely and usually only for very serious criminal misbehavior. Now, state court judges have terms. They are usually something on the measure of 4 to 6 to 8 years, depending on the different states. And if they are elected judges, they have to sit for re-election at the end of their term. And if they are appointed or granted their power by the governor, then in many states they have to sit for what is called a retention election, which is where the public then gets to decide whether or not to keep them on the state court bench. Many of these state court judges will later retire from the bench after 12 or 15 years and go on to have very successful practices as appellate lawyers. In addition to the individuals who are selected as state court judges, there may be other officers in the judicial branch who are not appointed as judges, but who serve in quasi-judicial roles. For example, commissioners. I'm a Missouri lawyer, and we have commissioners at the Administrative Hearing Commission, which is where people go to challenge tax rulings, and sometimes they go there to work on licensure cases, to appeal a licensure determination or discipline. And then in addition, we often have hearing examiners, which is the case for workers' compensation. These are administrative law judges who make determinations about whether or not someone gets compensation for a work-related injury. So those individuals are not considered judges, but they are exercising, at least to a certain degree, a measure of judicial power. They are treated differently, and their rulings are treated differently, and generally speaking, anybody who serves in that position as either a commissioner or a hearings examiner or an administrative law judge of some kind in a state court, their decisions will usually be appealable to the state court itself. Now, state court judges are not the only ones who have subordinate types of judicial officers. The federal courts have subordinate types of judicial officers as well. Administrative law judges in Social Security will make determinations about whether someone gets disability or supplemental security income, those sorts of things. And there are other administrative law judges in places like immigration. In addition to those, there are federal magistrates. Federal magistrates are appointed by the court where they sit. For example, in the District Court of the Western District of Missouri, the Western District Judges will get together and appoint a magistrate to serve as their magistrates. And usually there are more than 4 or 5 of those in any judicial circuit, and they handle cases that are less important, although they can handle an Article III case, which is a case that would normally be handled by a federal judge if both parties agree. And sometimes that's an excellent way to get a speedier resolution in a case than going through the federal judge. And then finally, there is the bankruptcy judge. The bankruptcy judge is what's called an Article I judge. In other words, he gets his judicial power through Congress, Article I, instead of Article III, which is the judicial branch under the United States Constitution. Bankruptcy judges are appointed for terms of 14 years, and they are supervised by the Circuit Court of Appeals in their circuit. They may resign more quickly than that, they may stay on the bench for less time, or they may get reappointed. It just depends. But they are considered to be bankruptcy judges, and they have almost the same amount of power as a federal district court judge, except that they can be overruled by a district court judge or the Circuit Court of Appeals. So how are judges disciplined when they make mistakes? Well, if they reach the wrong result or if they get appealed and overturned, there's no discipline associated with that. They just made an error, and the error-correcting function of the judiciary has fixed that error. There is no penalty to the judge for making an erroneous decision. However, if they engage in misconduct, they throw things at litigants, they yell, they scream, they use racial slurs, things like that, they can be subject to discipline through the Federal Judicial Commission. And indeed, there are state judicial commissions that do the same type of thing for state judges. Having a judge removed is fairly rare, and again, it usually results only where there's been serious misconduct. And in that situation, usually the Federal Judicial Commission will send a formal communication to Congress urging them to take action against a particular judge. I would point out to you that the distinction that you will often hear is about Article III judges. And Article III is Article III of the Constitution, and Article III of the Constitution provides for the appointment of the Supreme Court. And it allows Congress to designate inferior courts. There are none other than the Supreme Court listed in the Constitution. And it allows Congress to set the number of those district court judgeships and their location by statute. So that's why you often hear Article III tossed around in regard to judges and judicial officers. So if you found this interesting or helpful, I would really appreciate it if you would punch the like button there. And if you haven't already subscribed to our channel, please do so. It helps us out with the YouTube algorithm. It gets these out there for other people to see. And I think you would be doing people a service by letting them know about our channel. Please feel free to share this video with anybody that you think may benefit from it. Otherwise, I would appreciate it if you would like and subscribe, and have a great day, and we'll catch you on the next video. Thanks.